Hello, everybody. Welcome to the National Paralegal College Faculty's Legal Analysis of the News for today, and that is August the 13th of the year 2014. And what I would like to discuss today is the Tony Stewart situation. Tony Stewart, unfortunately, a few days ago, crashed into another driver who had stepped out of his vehicle during a NASCAR race, and Stewart's car hit him. And as you can see over here, Tony Stewart, the race car driver, was questioned in a potential criminal probe. Now, as we'll see in a little while, it doesn't look like he's going to be facing any charges because he doesn't look like there was really any guilty intent or mens rea, as they call it from a criminal law perspective. But what I want to discuss a little bit is I want to focus just a little bit on maybe not specifically the Stewart situation, since there really doesn't seem to be any evidence of wrongful conduct, but what constitutes homicide from a motor vehicle crash perspective. You can see over here that authorities did question Stewart and described him as visibly shaken, and the investigator said that there's no evidence at this point to support criminal intent, but said that criminal charges had not been ruled out, because there were at least some issues. Essentially what had happened is the other driver had gotten into a crash, and he had, it's not clear exactly what his motive was, but he got out of the car and started walking back onto the track where the other drivers were driving. And I guess there are some questions of exactly what happened next. Did Stewart try to send a message to the driver by driving near him? Of course, that might, if that happened, if Stewart actually drove close to him intentionally in order to try to send some sort of a message, that might establish guilty intent. That might establish at least negligence or recklessness. Or did Ward simply take his life into his own hands by stepping into traffic in a black fire suit on a dark track? It was at night when this happened. And they have an expert attorney over here who commented that even with the video, it's going to be tough to prove that this was more than just an accident, or even that there was culpable negligence. Now, this did occur in New York, and so we are going to look at what the standards are relevant when you're talking about automobile deaths in New York. Now, unfortunately, I checked and there really isn't any case law about people dying during NASCAR events, and the questions of whether they can be prosecuted for various levels of homicide. So what I'm going to do is I'm just going to try to take you through some of the standards when it comes to other sorts of automobile deaths. In the Stewart case, as I mentioned before, it looks like at this point at least there are not going to be any criminal charges filed. You can see this headline, Stewart facing no charges for the fatal accident. Another article, similar, also says that there's no criminal charges. Another article over here from ABC News saying that the probe did not find any criminal behavior. So let's take a look at the New York rules and how they establish criminally culpable homicide when it comes to a death by automobile. In New York, and this is fairly similar to what many other states do, there are 5 different levels of homicide, ranging from first-degree murder, which is a Class A felony punishable by up to life imprisonment without the possibility of parole, all the way through criminally negligent homicide. First-degree murder means intentional murder with some sort of aggravating circumstance, something like commission of a intentional murder in the course of committing a different felony, killing a police officer or a correctional officer in the course of his or her duty, etc. Second-degree murder, which is punishable by 25 to life, is intentional or depraved indifference murder. Somebody exhibited conduct that showed depraved indifference to human life, and a person died as a result. Then you have voluntary manslaughter, a Class B felony, punishable by up to, I believe, 25 years in prison. And that could be because there was intent to cause serious harm. You tend to just beat somebody up and death results. Or an intentional killing, but there's a mitigating circumstance of heat of passion. There was some sort of a huge, good reason why the person was very angry. Doesn't excuse the conduct, but it does decrease it from murder to manslaughter. There's involuntary manslaughter, which essentially means the person was reckless, and that recklessness caused the death of another person. And then you have criminally negligent homicide, where you have negligence, and that causes the death of another person. And I'm going to focus on this bottom level over here because I think, especially in the Stewart case and in many accident cases, the top 4 the top four probably are not relevant. The recklessness standard, by the way, is what is very often used when you're talking about people who are drunk driving. People who get wasted and then go out and drive and they kill someone are very often charged with recklessness, or very often charged with involuntary manslaughter. But clearly, I don't think recklessness has much of an application over here. Recklessness is when you intentionally ignore a risk that you know about. You intentionally engage in conduct that you know is risky to human life. I don't think that's what happened over here. Even worst case scenario for Stewart, and again, it doesn't look like he's going to face any charges, but worst case scenario is probably criminally negligent homicide. So this is the criminally negligent homicide statute in New York. It's a Class E felony, which I believe that it means that it's punishable up to a maximum of 4 years in prison. So obviously nothing near what manslaughter or murder would be, but still a fairly serious charge. And it says, very simply, the whole statute is one sentence long. It says a person is guilty of criminally negligent homicide when, with criminal negligence, he causes the death of another person. Okay, well, that doesn't really give us a whole lot of information, because the elephant in the room, so to speak, is what does that phrase mean? Criminal negligence. Is that the same thing as civil negligence? If you can be sued for negligence, does that inherently mean you're guilty of the crime if a death results, or is it some other standard? And for that, we have to look at the case law. So let's look at some cases that will help us define criminal negligence for purposes of being guilty of homicide. The first thing is, and this is really a matter of well-settled law, and that is criminal negligence for purposes of criminally negligent homicide means something more than mere civil negligence. The sort of negligence that would get you liable in a tort case is not necessarily enough to get you guilty in a criminal case. So culpable negligence within the meaning of this sentence, actually this was manslaughter in the second degree, because in those days, this is back in 1927, in those days that was the statute that was equivalent to today's criminally negligent homicide. But it says more than slight negligence necessary to support civil action for damages. It means disregard of consequences which may ensue from an act, and indifference to the rights of others. It means, and this is from another case, much more recently, a New York Court of Appeals case in 1989, says that you need a gross deviation from the standard of care which a reasonable person would have observed under the same circumstances. Now, for those of you who may have studied torts, when it comes to a tort issue, when it comes to being liable for negligence in a tort case, you don't need a gross deviation from the standard of care. All you need is even a slight deviation from the standard of care. So the idea of being negligent in a criminal context is more hard. It's harder to be negligent in a criminal context than it is to be negligent in a civil context. Just because you are liable in tort for negligence does not inherently mean you are liable for crime in negligence. Let's take a look, in fact, at some of the automobile cases, just to show you how this works in this kind of a context. Mere negligence is not enough. This case, also a New York State Court of Appeals case from the same era that we looked at before, same era as the Ricardo case. We had the defendant's truck on a dark, rainy night with fog struck a stopped police vehicle sitting in the right lane. You can probably picture the scene. It's dark, it's rainy, it's foggy. Driver didn't see the police vehicle. The truck didn't see the stopped police vehicle, smashed into the police vehicle, killed two people in the police car, and because they didn't see it, basically they didn't see, and they were charged with criminally negligent homicide for failing to see the police car that was stopped in the right lane. And the court said, the New York State Court of Appeals, said that there was no criminally negligent homicide in this case. The court reversed the order of the lower court, which had said that criminally negligent homicide could apply, and the court said that criminal liability could not be predicated on every act of carelessness, but the carelessness had to be such that its seriousness would be apparent to anyone who shared the community's sense of right and wrong. And the idea of driving a truck and failing to see a stopped police car in the right lane, although it perhaps was negligent, and certainly is the sort of thing you want to watch out for when you're driving. You want to make sure you don't run into any cars. It doesn't rise to the level of being serious enough to be considered criminally negligent homicide. Could there have been civil liability? Could they have sued for wrongful death? Very possibly. But it does not rise to the level of criminal negligence for the purpose of conviction for criminally negligent homicide. Even speeding, in and of itself, has not, at least in a series of relatively old cases, cases from the 40s and that era, has been held to not establish criminally negligent homicide. In a case called People v. Bearden back in 1943, also a New York State Court of Appeals case that, as far as I know, is still good law, speeding at 50 miles an hour on an avenue in New York City. Now, today, the avenues of New York City usually have speed limits of 30, so a fairly substantial amount over the speed limit, is insufficient to establish disregard of the consequences of the act and indifference to the rights of others. Proof of speed may lead to civil liability. In fact, for those of you who have taken torts, you may recall that speeding inherently means you're negligent from a civil standpoint, because there's a doctrine called negligence per se, which says that if you're breaking the law, you are inherently considered to be negligent, but that is not true when you're talking about a criminal context. Another case, same era, 1946, similar result, where evidence indicates the defendant's car approached the intersection at 40 miles an hour, but that brakes were applied 18 feet from the intersection, and the car skidded for 42 feet where the collision occurred. There's no evidence of negligence, even though the speed limit was, I believe, 30 in that case. He was speeding, slammed on the brakes, didn't work, smashed into someone. Very well may be civil liability if you're speeding, but there is not going to be criminal liability. So where do you have criminal liability? What do you need in order to establish criminal liability for a vehicular accident? Now, I'm not even going to get into drunk driving because that's obviously criminally negligent, at least criminally negligent homicide, maybe even involuntary manslaughter. There have been some famous people, as a matter of fact, like Bruce Kimball, the former Olympian, who won a silver medal in 1984 for diving, was later sent to prison for manslaughter when he got drunk and ran into and killed 2 pedestrians. So drunk driving is clearly drunk driving and killing someone clearly implicates liability for homicide. But what about other less severe cases? Well, in People v. Hanley, we had something where a person was convicted for criminally negligent homicide when the defendant sped and ran a light. Defendant, while traveling at an excessive speed, ran a light and struck and killed a pedestrian. And then we have some procedural over here, and the appellate court reinstated the indictment, which means there could be criminally negligent homicide, because the evidence supported, since the charge required only that a culpable failure to perceive the risk where one had a legal duty to be aware of the risk. You have a legal responsibility to be aware of the risk when you run a traffic light that you may actually get into an accident and might hurt someone. So even though speeding alone may not be enough, speeding and running a light, which, I think most of us would probably consider that more dangerous. Speeding is one thing. Very often, especially, we all know, you drive on a highway where the speed limit is 65, you can still fairly safely drive 70 or 75. Most people would not really consider that very risky conduct, very egregious conduct, but running a light, especially at a high rate of speed, is considered more risky and therefore allows the potential for a conviction for criminally negligent homicide. Let's look at some other cases now in which we had convictions for vehicular accidents that resulted in death for criminally negligent homicide. Well, how about speeding, but not just regular plain old speeding, speeding in a manner that is unsafe? The defendant attempted to pass several cars on a 2-lane highway, in other words, 1 lane in each direction. Sometimes, especially in the country, they have like a dotted line where you're allowed to pass, but it still is fairly dangerous. And there was a restricted view, no passing zone. In this case, you weren't allowed to pass, and the defendant passed someone going 75 miles per hour. And the defendant tried to pass someone, had insufficient space to move back into the lane, and collided with the car. 2 people were killed. Defendant is convicted of criminally negligent homicide. And I might even say that the defendant was lucky not to have been charged with manslaughter. Driving 75 miles an hour and trying to pass in a no-passing zone clearly is dangerous. Another fairly obvious example, in this case, the defendant was driving 90 miles per hour was aware that he was traveling through a police radar area, where there are police officers standing around in cars, saw a line of traffic backed up and was warned by the passenger to slow down, but instead accelerated and struck and killed a state trooper. Again, that's another case where there's fairly obviously criminally negligent homicide, and if not, even recklessness, which would allow a conviction for manslaughter. You don't even have to be the driver. Look at this case. Look at People versus Garris, a 1990 case. The defendant wasn't even in the driver's seat. The defendant was in the passenger seat. And the defendant grabbed the steering wheel and jerked it downwards, causing the vehicle to veer off the road and strike and kill a pedestrian. And the court held that the court understood that the defendant didn't have any reason to touch the steering wheel, and just did so, I guess, to be amusing, or I don't know exactly why people who are in the passenger seat feel the need to grab the steering wheel, but still, either way, whatever the motive was, the evidence supported the jury's finding that the defendant had failed to perceive a substantial and unjustifiable risk, and therefore that was sufficient to sustain his conviction for criminally negligent homicide. So getting back to our case, now in Stewart's case it's obviously very hard to determine exactly what happened, but the standard, and the standard by which this case and every other vehicular accident will be judged, is more than just ordinary negligence. Was there a substantial risk? Was there an obvious risk that you failed to perceive, that you should have been aware of, and that you should have compensated for, and that you should have behaved in accordance with, and that you didn't do it? Merely speeding? Not enough, because merely speeding, even though it's illegal, doesn't really strike the ordinary person as being such a risky behavior. Running a light at a very high speed, driving way over the speed limit, like 90 and a 55, driving, through barricades, driving in an area where someone warned you to slow down and you sped up instead, reaching over and grabbing the steering wheel from someone and and turning the car and so that it smashes into a sidewalk and ends up killing a pedestrian there. Even if you don't know the pedestrian is there, that could be enough to be considered criminally negligent homicide, at least in the state of New York. And again, if it's reckless, if it's even more wild, if it's even more reckless conduct, it could be manslaughter. And if the conduct is really seriously reckless, it could even rise to the level of being depraved indifference to human life, and thus rise to the level of second-degree murder. So, thank you very much for listening. I hope you've enjoyed this little presentation. This is Stephen Haas for National Paralegal College. Have a fantastic day, everybody.